The U.S. Supreme Court handing down two big decisions today in cases that have made national headlines.
In one case, the court ruled that violent threats made online can be okay. This stemmed from the case of a Pennsylvania man who was prosecuted for making threats on Facebook about killing his ex-wife and harming others. Chief Justice John Roberts said the prosecutors need to do more than prove that reasonable people would view the statements as threats. He overturned the conviction, saying there needs to be proof that there was intent when the man published threats directed at his wife. The High Court did not issue sweeping protections, though, for things written online.
There's a big decision today, the court ruling in favor of a Muslim woman who sued Abercrombie & Fitch. She claimed she was denied a job because she wore the headscarf, a hijab, for her religious reasons, and Abercrombie said this violated its, quote, look policy. She wore the hijab to an interview, but didn't tell the company she wanted a religious accommodation. Today, the court said she didn't need to do that to receive equal protection for employment. In a statement, Abercrombie said the case will continue and pointed out the court did not determine that discrimination took place.
Joining us now to discuss these cases is 7 legal analyst Tom Cranmer. Tom, good to see you this afternoon. Thanks for being here.
Great to be here.
Let's start with that Facebook case. The court says there needs to be proven intent. Define that for us. What does that mean legally?
Well, Joanne, what that means really is that this Supreme Court decision is a narrow one. While it does uphold the notion of freedom of speech, what the court indicated is that what the prosecution has to prove is that the person who made the threats intended the threats, and that these weren't just a matter of free speech or expression, but there was an actual intent behind the threats that were made.
Those expressions were fairly violent. The guy wrote things like he wanted to see his wife's head on a stick, implying that he'd be willing to carry out a school shooting. I mean, it seems like intent, or is the court saying, hey, you can't believe everything you read on the internet?
Well, it certainly does seem that way, doesn't it, Stephen? But what is important to note is that what the Supreme Court said is that we're going to send this case back down. We're going to send it back down to the trial court to make that important determination as to whether or not there was intent behind these threats.
And then if they decide that there was, my understanding is his conviction would be upheld. But if there wasn't intent and they don't prove that, then it would be overturned. But let's talk, Tom,
exactly right.
about this. What does the standard of proof then need to be to convict someone for threatening speech online? I mean, is proving intent a difficult thing?
Well, in some respects you would think that it would be, but that really is something that occurs in almost every criminal case. You have to show or have to prove intent. And in this particular instance, what the court said is that we have to be careful not to just make freedom of expression, if you will, a crime. But if there's intent to do harm, intent to do violence, that is a crime. And if the prosecution shows that, there will be a conviction.
No, so, Tom, you know somebody's going to be watching this news. I mean, getting the people who do this kind of thing read. They're going to read this and they're going to say, hey, I can go out and I can threaten anybody I want on the internet because the Supreme Court says it's okay. Do we see this opening a door?
You know, potentially, but in reality, I don't think so, Stephen, because if you really look closely at the decision, it's actually a rather narrow decision. Again, they're upholding freedom of expression, important personal right, but they're also saying that if there is intent behind the threats and the prosecution can prove it, then that's a crime, and that's something that will be a conviction.
Tom, let's move on to the second case we were talking about now. It's the case of the Muslim woman. The court sided with her in this case, we understand. They did not determine, though, as Abercrombie points out, that there was discrimination. How did they end up siding with her?
Well, again, Joanne, I think this is just an extension of what the Supreme Court has said oftentimes in the employment arena, and that is that you cannot discriminate against an individual on the basis of his or her religion. That goes for hiring, firing, job promotions, and the like. Anything that potentially is discrimination will not be tolerated.
Now, as we pointed out, and Abercrombie points out, she admits that she never actually said, I need a religious exemption because I'm wearing this. Right. So is that something also, no longer do you have to say it? You just assume that the business is going to know it?
Well, that would appear to be the case, Stephen, because this was an 8-to-1 decision, and Justice Scalia, writing for the majority, said, well, she didn't say that she needed that religious accommodation, but the employer in this instance, based upon the hijab and the way she was dressed, should have figured that out.
Tom, this is the second year, I know, that in this year that the court has issued a ruling in favor of alleged Muslim discrimination. We've also seen other cases they've taken a more really expansive view of religious rights. Has this court, do you think, been more likely to side with religious freedom? Is that what we've been seeing?
I think so, and this is just another indication, as you've indicated, Joanne, of their willingness to be very protective of religious freedom and religious rights.
We've got some big cases still to hear from the Supreme Court this year, don't we, Tom?
We definitely do, and it'll be interesting to see what they do in those cases as well.
Yeah, any indications from what you've seen so far from them of a change in direction we might see from the court on these other rulings we're looking for?
I don't think so. You know, again, the court splits to some extent down ideological lines, although interestingly enough, in this past case that we just saw with regard to religious freedom, they were almost unanimous in their decision.
Yeah. The same-sex marriage, of course, the big one that we're expecting by the end of June. Tom Cranmer, thank you very much, as always.
All right, guys, thank you.